Thank you, Ed.
Well, I just want to welcome Barbara. I'm a member of the Civic Engagement Committee, so I'll speak for us, even though no one else is. I want to welcome you, and I am feeling really privileged to have your wisdom because you are really a pro on this and will open our eyes. And I'm looking forward to hearing how Madeline introduces you. So thank you for being here.
All right, so Barbara knows I kind of touched base with her today, and we had a wonderful bio for her, and I'm just gonna work from that. And then Barbara, of course, feel free to add anything else. So, but I'll just start by saying, even before I get to the bio, I met Barbara 2 or 3 summers ago at the Judicial Nominating Convention up in Albany, the Democratic Judicial Nominating Committee. And I mean, it was just a wonderful meeting with, we sat down and had lunch together. Even though I didn't know Barbara and I did not know Essie Lewis, but I had lunch with them. And if you would ask my daughters how I raved about meeting these 2 young women that were so impressive to me. And so it's kind of been, I've been in touch with her since. So Barbara Graves Poller is her name. She serves as the Corporate Counsel for the City of Kingston, a graduate of NYU School of Law. She has practiced commercial litigation before clerking for a federal judge in the Southern District of New York. She's held supervisory positions at legal nonprofits and was included on the New York Law Journal's Rising Stars list for her public interest advocacy. She served as senior counsel in the New York City Law Department, where she successfully resolved high-profile disputes in state and federal appellate courts. The city honored her pro bono work on behalf of migrant women whose children were forcibly removed at the U.S.-Mexico border. Before becoming an attorney, Ms. Graves Poller earned a bachelor's degree in linguistics and cultural theory from the University of Pittsburgh, where she conducted advanced research on race and gender mobilization in post-dictatorship Brazil. Sounds pretty impressive to me. She then joined Teach for America, and afterwards earned a master's degree in human rights education from NYU. She's served as an officer of the Metropolitan Black Bar Association and is a leader within the Minority Voting Rights Committee of New York Democratic Lawyers Council. And you guys may have gotten email from them. NYDLC is the acronym. Since 2004, she has led teams of election protection attorneys in New York, Pennsylvania, and Michigan. And she is married and has a beautiful daughter and a wonderful husband too, and has relocated to Ulster County in 2020. So I am going to turn this over to you, Barbara, and please forgive me that I have to leave. I am in a church meeting. We are trying to get a pastor, and I'm on the search committee. That meeting started at 6 also. So I'm going to bow out at this time, but presenting to you then, Barbara Graves Poller.
Thanks, Madeline, and I'm glad to be a member of this chapter and happy to be here. There's so many urgent issues bubbling up through our courts. When I was originally thinking about presenting tonight, I thought about a range of topics in Supreme Court decisions that impact environmental concerns, our access to health care, and economic justice. There are cases like that bubbling up through the federal courts and our state court system of critical importance. But at the end of the day, without the right to vote, our voices will never be heard on these policy matters, and each of them literally is of life and death importance. I was in Chicago a few weeks ago and had the honor of hearing NAACP President Derek Johnson speak during the Democratic National Convention. And he used his opening remarks as an opportunity to remind all of us about the importance of the protecting and supporting and advancing the interest of Black voters, and took us back to 1964 and talked about how the Mississippi Freedom Democratic Party and the role that Fannie Lou Hamer and the NAACP state president from Mississippi, Aaron Henry, the role that they played in transforming the convention process to make sure that Black voters' voices were not suppressed. We are very familiar with instruments, the traditional instruments of Black voter suppression, which historically is centered on domestic terrorism and physical violence. But while that still happens, and while those words of the president were so powerful, impactful for us who were all in attendance, what I want to talk about tonight is a very different sort of Black voter suppression that has transformed into a far more technological approach, as opposed to the physical violence that sometimes happens, but is not the mainstay these days. But this technological approach, unfortunately, has also been blessed by many courts, and even the majority of the current Supreme Court. But before I dive into the Supreme Court decision that I want to really focus on for tonight's discussion, I just went through my inbox of current voting rights litigation and voter suppression actions in the courts. And I just want to mention the top 3 items that are in my inbox. The first one is from today. Many of you probably saw what's going on in Arizona, that there are about 100,000 individuals who registered to vote, but now their ability to actually go and cast a ballot is in peril because of changes that went into effect in a driver voter ID law back in 2024 that now requires some additional proof of citizenship. So potentially 100,000 voters in Arizona, their voices may be silenced. Last week, a Pennsylvania court issued a procedural ruling in a case that was brought by a group of advocates, including the Black Political Empowerment Project and the League of Women Voters of Pennsylvania. They were all fighting to make sure that mail-in ballots are not destroyed for minor errors. I don't know how many here have had to fill out the mail-in ballot form, but sometimes there's sort of complicated rules about the envelope and signing and dating the envelope. And the litigation in that case was brought to make sure that those votes were not just tossed aside because of some error that could be cured. Unfortunately, the Pennsylvania ruled in a way that will make that harder. And then last week, there was litigation out of North Carolina where a lawsuit was brought against the North Carolina Board of Elections to prevent students from using the digital versions of their ID cards as proof, acceptable proof at the polls. And I could go on and on for the entirety of my time talking about litigation meant to suppress voters, particularly younger voters, Black voters, language minority voters in key parts of the country. I'm not going to spend all of the time on that, but I just want to bring it to your attention that this feels very different from the type of history that President Johnson talked about from back in, the 50s and the 60s, and even different from what we saw before the 2020 election. Until recently, we've mostly been focused on what I'd call the front end of voter suppression, and that is things like whether it's the terrorism or the ID laws, also poll site locations, closing those locations, taking them out of areas where there are large concentrations of Black voters. But 2020 saw a kind of thrown together variety of back end efforts at voter suppression, and that really focuses on attempts to stop counting votes or throw out ballots. Many of you probably know that in the state of Georgia, there are new vote certification procedures in place post-2020. And all of that is a new form of either voter suppression, or we can call it election interference in some respects. But that is what we're looking at now in a much more coordinated fashion. Fortunately, there are a lot of voting rights advocates who are working to resist that trend. But there's another type of voter interference that's really been going on in earnest since 2011 that I want to focus on tonight, and that is racial gerrymandering. So the bulk of my remarks now are going to be focused on issues surrounding racial gerrymandering that really crystallized in the case Alexander versus South Carolina State Conference at the NAACP. I don't know, is anyone here familiar with that Supreme Court case that came down in May of this year? I don't see any thumbs up. All right, so I will maybe give a little bit of background. Because that case, which you can tell just by the name of it, involved the NAACP, was about racial gerrymandering and the redistricting process. Now, I don't know if I'm able to share screen, or maybe it's not even necessary to go through that, but are you all familiar with the concept of racial gerrymandering or race-based redistricting? I see a couple of nods.
Yes.
So, when I was trying to summarize it quickly, redistricting of this kind, it really is the opposite of the electoral process. It is reverse engineering an outcome in election based on how people who draw maps pick their voters. The image I was going to show you all, which I'm happy to circulate later, was just a really simple graphic that shows you can have the same number, let's say, of 100 precincts or 100 persons, 100 groups, and depending on if they're split 60-40, you can cut them up so that the 60% group, let's say, wins 100% of the time. And you can cut it up a different way, depending on how you draw the lines on that map or that grouping. And that minority group, the 40%, can win 100% of the time. Redistricting is the process by which, unfortunately, map makers pick their voters, and they can pick them in ways that essentially make it impossible for whoever the minority group is, whether it's a political party or, in what we're talking about tonight, a racial group, to have their voices heard. And so I just want to touch on, a couple of those principles. The way that you do that when you're drawing, let's say, suppressive maps, is that on one hand, you want to pack as many of the minority voters into one district as possible. Because if you think about it, if you have a race, in my hypothetical, you have a 60-40, right? Everyone who's above the 51% is essentially, or depending on how the lines are drawn, is potentially an excess vote, if that makes sense. If we're talking about needing to win by 51%, if you pack, for example, all of the, we'll just say, Black voters in an area, you want to create what back in the day they would call a containment district, and pack as overstuff a district with as many of the minority as possible, so you give them that seat. But then you, and the term is crack, instead of packing, you crack up that group into these different districts, essentially diluting their ability to affect the outcome in all the other districts. So I didn't come up with these terms, but cracking and packing are the way people tend to talk about the gerrymandering process. If you can't lump everybody together, then you break them up to sort of dilute their power by spreading them out in ways so that they can never coalesce around a candidate. So, because voting is the civil right used to guarantee all other rights, you would think that the Supreme Court of the United States would want to play an important role in guaranteeing that right. And sometimes that has been the case, but not always. So if you'll just bear with me as I touch on a few cases over the years, I think it's worth understanding kind of where we are in this arc of protecting voters from this type of redistricting related suppression. So if we want to go back to 1962, again, this would be a couple of years before that Mississippi Freedom Democratic Party was talked about at the convention. Baker v. Carr was a 1962 case that was about redistricting out of the state of Tennessee. And the plaintiffs in that case brought an equal protection claim based on the lines drawn for their state general assembly districts. Those districts did not have equal populations. Now, districts don't have to be equal down to one person. You know, there's going to be a slight variation. But like I said before, if you draw districts that pack, say, all of your Black voters into one, you could have one district that's huge, one district that's quite small, and yet their elected representatives have equal power. That's not really fair. Okay, so Baker v. Carr was the decision that said, and this is when Justice Brennan was writing for the court, he said that those kind of claims are claims that you could bring to the Supreme Court. The term is justiciable. So it means that they're capable of being brought in the court, and the court can, you know, evaluate them and potentially offer some remedy. 2 years later, Supreme Court decided Reynolds v. Sims. And in law school, this is the kind of case you always remember, because that was a Warren Court decision that established one person, one vote as the general rule. One person, one vote means that when we're carving up these state legislative districts, that they should be roughly equal, maybe off a few numbers here or there, but not wildly so. Same year, Westbury versus Sanders. That one person, one vote standard was applied to Georgia's congressional districts. So I'm going to skip ahead and remind us all of what happened in 2013. We have changes in pre-clearance requirements because of the Shelby County versus Holder decision, which essentially gutted the Voting Rights Act, at least the pre-clearance requirements as we knew them before. That changes the landscape. It also signals a very different approach of the Supreme Court, or that the Supreme Court's going to have in protecting voting in a variety of contexts. Fortunately, we had a couple of bright spots. In 2016, there was a case, Evanwell v. Abbott. And I don't know, this case didn't get a lot of publicity, or certainly not as much as I think it should have, because this time the roles were flipped. You didn't have plaintiffs who were coming in complaining about unequal districts so that they could expand the franchise, essentially, or expand the power of voters. What you had was a claim that Texas was violating the one person, one vote requirement because its districts were based on census data. What's wrong with that? Well, the plaintiffs in this case wanted to exclude everyone except registered voters. So if, say, you had a family, you have minor children, they didn't want your children to count. If you were not registered, or if you were, say, not even a citizen, they didn't want you to count. Fortunately, the Supreme Court rejected that. And so we still have, you know, the census as the basis for drawing district lines. The next year in Cooper v. Harris, and this is an important case as we go forward, that involved racial gerrymandering. And those claims came out of North Carolina. Justice Kagan was writing for the majority as it existed at that time. Justice Alito dissented. But that case set standards for how plaintiffs who felt or who believed that their votes were being diluted through racial gerrymandering, how they bring those claims. And they could actually bring the claim. And they could seek redress in the federal court up to the Supreme Court. So now we start getting to the key case for tonight and its precursor, Rucho versus Common Cause. That case was about what's referred to as partisan gerrymandering, meaning if you have a state legislature that's controlled by one party and they come up with a system for drawing lines for whether it's, you know, their congressional districts or what have you, can they draw those lines in a way that guarantees their party will win a majority of the seats, if not all of the seats? And the majority of the Supreme Court said, okay, that's fine. Or at least that you can't go and seek the Supreme Court's intervention on behalf of the minority party in that case. So I know I just kind of skipped over or flew through pretty quickly a bunch of key cases, but they really boil down to about 3 issues, at least the way I see it. When should the Supreme Court intervene to protect voters, whether of a minority party or a minority racial or ethnic group? What type of evidence do those plaintiffs have to come forward with to prove their case at the trial level? Again, the Supreme Court is looking at the appellate level, but when you first get to court or bring your claims to court, it's going to be in a district court. How do you prove that? And then the third issue is what standards are supposed to apply if and when you get up to the Supreme Court. All right. So if I haven't lost everyone yet, let's go straight into the heart of this Alexander versus South Carolina NAACP case. I usually find it helpful to just go through who, what, when, where, why, and how. So we've already talked a little bit about the how with this history, but who? The South Carolina Conference of the NAACP brought the lawsuit. They were joined by the ACLU and other related entities, different chapters and sort of sub affiliates of both. They sued the state South Carolina Senate and State Election Commission, along with other entities involved in drawing the maps. What was the claim? The claim is that was that the 2022 South Carolina congressional maps were racially gerrymandered, meaning that they were drawn in ways to intentionally disempower Black voters. When did it happen? After the 2020 census results came in. Because like I said, when we were talking about the Evanwell case, census data really is the foundation, or should be the foundation of this process. Where? The focus was on the Charleston metropolitan area. Congressman Clyburn represents Congressional District 6. This controversy centers on how the state's map makers handled population changes in the adjacent district, Congressional District 1. And like I said, why is it that this happened? It really does go back to that last case that I talked about, the Ruscio versus Common Cause decision. In that case, 5-4 decision by the Supreme Court in 2019, they said that party gerrymandering is a political problem that federal courts should not weigh into. In other words, the Supreme Court will not wade into questions of whether or not the Democrats drew a congressional map that made it virtually impossible for Republicans to win, or vice versa. The issue, though, is that that decision left open the question of whether map makers are making decisions based on party affiliation or based on race. And we know that there are correlations. All right, so what did the NAACP say in this Alexander case? The NAACP and the other plaintiffs claimed that the state's map makers adopted a racial target of 17% of the Black voting age population for each precinct. And I'm going to pause there for a minute without taking you too far down the tangent. That when we start talking about this Supreme Court and racial quotas, we know that they were extremely hostile to any notion of a quota when we were talking about things like college admissions. Even if there were other factors being considered, the very concept that race mattered at all was anathema to this majority. And they believe that race, we're supposed to be colorblind, colorblind, colorblind. Okay, but the NAACP here alleged that this map was based on a specific numeric target of Black voters, and that the maps that were created achieved that target by really doing what I think of as a two-step. So Congressional District 1, the population had grown. Everybody knew that. So you'd think, okay, well, you could, move some voters from 1 into 6. That might make sense given the geography, how, the population is spread out. But that's not what happened. The NAACP said that the defendants could have equalized the populations by simply shifting people from 1 to 6, but instead, the map makers first moved more voters in to Congressional District 1. So they took an overpopulated district and made it more overpopulated. And then they surgically went through data and moved Black voters out. so as to achieve that 17% Black voting age target in each of the precincts, because they have very sophisticated behavioral models that showed once you got the Black voting age population above 20%, that became a contested district. And basically, the map makers wanted a safe Republican district, and they knew that they could do it by controlling the Black voting age population. And so in the end, and here I'm quoting from the word that the NAACP used was bleached, that defendants bleached Charleston County of 62% of its Black residents, removing every precinct but one with more than 1,000 Black voters, creating a non-contiguous district. I won't drag you into the weeds of it, but basically when you're drawing maps, you're not supposed to make a bunch of little squiggles. There's supposed to be a bit of logic into how the lines are drawn. Maybe you draw the line at a river, or something that makes sort of sense, and you're supposed to be able to travel through a district in a sensible fashion. And the plaintiffs alleged that didn't happen here. The lower court, so the district court, conducted an 8-day trial that had dozens of witnesses. I think the number was 42. Hundreds of pieces of evidence. The record was more than 2,000 pages long. A 3-judge panel invalidated South Carolina's Congressional District 1 and said that it was an impermissible racial gerrymander and that race was the predominant factor in adopting that plan. This Supreme Court reversed, put the state's congressional maps back in place, and went on to order the NAACP to pay $6,129 to the state in litigation costs. So let's see what they said. Remember, I kept talking about that case from 2017 that Justice Kagan wrote the majority and Alito had the dissent. Well, the composition of the court has changed and now it's flipped. So Justice Alito wrote the majority opinion here. He spends, the majority opinion spends a lot of time saying we must presume that the legislature acted in good faith. Now that's a well-settled legal principle, and quite honestly, in my work, I rely on that principle. But the way that it's used here actually reverses the process for analyzing what happened at that trial. There was a trial, there was evidence, there were factual findings by a district court. And yet when the Supreme Court majority looked at it, Justice Alito said, we should not be quick to hurl accusations against the legislature, alleging that they engaged in offensive and demeaning conduct. And when you read that, when you look at how much time the majority spent on that principle, it's as though they've elevated the accusation of racist behavior above actual racial gerrymandering, because racial gerrymandering is what the court below found, documented, explained with clear citations. Then Justice Alito said, plaintiffs' evidentiary burden in these cases is especially stringent. Why? There was a standard. And I keep harping on that Cooper case from 2017 because it was only 2017. We all know when, they're Supreme Court nominees, they come before, the Senate, we all watch them and they talk about adhering to precedent. Stare decisis, I have to follow the law. The law in 2017 explained how you make a racial gerrymandering case if you want to prove it. And now the evidentiary burden, the goalpost is shifted. Let me go to Justice Thomas, what he said. Now, Justice Thomas has long articulated a vision of the Civil War amendments, 13, 14, and 15, that differ radically from how many legal scholars understand the purpose and intent of those amendments. What he said goes back to that term justiciable that I used early on when we talked about Baker v. Carr and Reynolds v. Sims. Justice Thomas said, the court has no power to decide these types of claims. Drawing political districts is a task for politicians, not for federal judges. Racial gerrymandering and vote dilution claims brought under the 14th and 15th Amendments are non-justiciable. And those are exact quotes. It goes on, Justice Thomas skips over a lot of recent history, including the cases that, you know, we touched on at the outset of my presentation. And he goes back to the Federalist Papers. And he said it's Congress, not the courts, that our founders contemplated would provide recourse against state intrusions on voting rights through the districting process. So too bad, so sad, you cannot look to the Supreme Court to guarantee rights, voting rights under 13th, 14th, and 15th Amendments when you're talking about this type of voter suppression against Black Americans. And, you know, I've been characterizing people or summarizing people's, you know, the claims and things. I don't want to summarize Justice Kagan's dissent. I just want to read a paragraph from it, if you'll bear with me, because her words are so powerful. She said, in every way, the majority today stacks the deck against the challengers, or the NAACP. They must lose, the majority says, because the state had a possible story to tell about not considering race, even if the opposite story was more credible. And they must lose again, the majority says, because they failed to offer a particular form of proof, which they did not know would be relevant and which this court recently told plaintiffs was not required. It does not matter that the challengers offered extensive evidence, including statistical analyses, that the state's districting plan was the product of racial sorting. It does not matter that the state, by way of response, offered little more than strained and awkward denials. It does not matter that 3 judges, entitled to respect for their factual findings, thought that those denials were not believable and did not put a dent in the plaintiff's proof. When racial classifications in voting are at issue, the majority says, every doubt must be resolved in favor of the state, lest, heaven forbid, it be accused of offensive and demeaning conduct. What a message to send to state legislators and map makers about racial gerrymandering. For the reasons I've addressed, those actors will often have an incentive to use race as a proxy to achieve partisan ends. And occasionally, they may want to straight up suppress the electoral influence of minority voters. Go right ahead, this court says to states today. So, yeah, I have a lot of thoughts and obviously a lot of feelings about this, but I'll just make a couple of quick comments before. I know you wanted to have a Q&A session a bit, so I want to make sure we leave time for that. But at the end of the day, we have to be looking at our states, our state procedures, our state constitutions. As many of you know, we've had a long and complicated redistricting process here in New York State because there were claims brought under the New York State Constitution. Some state constitutions still forbid partisan gerrymandering, and that is a good thing for democracy. But it's not just looking at our state remedies, it's also making sure that when we're talking to voters, that they understand the importance of non-presidential year voting. When we look back at the changes in state legislatures that really took off in earnest, or the focus of the preparation for partisan gerrymandering that really took off in earnest in 2011, and then went into hyper mode after 2018. I mean, low turnout in our state legislative elections, or even in elections of state judges, that spells doom for democracy. We need to encourage broad participation in these off-year or non-presidential elections because they have incredibly powerful consequences during congressional and presidential election cycles. So maybe I should just pause there. I know I kind of went over a lot of material, but I'm happy to try and answer questions if I have the answers, but I'll tell you honestly if I don't.
I have a
Hey,
question.
Gammy, go ahead.
Yes. I'm wondering, okay, the Supreme Court literally dismantled the first Voting Rights Act. And if the John Lewis Voting Rights Act passes, is there any fail-safe within the act itself that would prevent the Supreme Court from also dismantling what that is? I mean, it seems like they have indeed the supreme power to just, you know, get rid of anything that they don't like. So, we're talking about, oh, we have to pass the John Lewis Act, but the same thing could happen, could it not?
So I'll give a lawyerly answer. I don't have the text of the proposed act in front of me, but what I can tell you is, there has to be constant vigilance. And, we can't take the position that simply passing strong voting rights legislation at the congressional level is ever enough. I know that many nonpartisan legal scholars are in favor of Supreme Court reform. I wouldn't call myself among their ranks, but I certainly am in favor of Supreme Court reform. But again, we also, I'll just speak personally. When I was in law school, it was at a different moment. And we always thought federal. And then when I'm saying we, I mean people who tended towards being pro-voter, pro-inclusion, pro kind of diverse, robust participation. And we always kept our eyes trained on federal opportunities, both for litigating and for enforcement. And I think that cannot be the way that we strategize going forward. It hasn't been for a while, but certainly after decisions like the Alexander case that I went over, I mean, we can't think in that sort of silver bullet fashion when it comes to protecting Black voters.
So there's no answer. I mean, the Supreme Court will continue to do what it's doing unless it gets somehow reorganized, or I don't think just rules how they should act is going to affect any legislation. It seems like they have the power to, just discard legislation. It doesn't matter.
In some respects, yes, but again, I'll go back to the fact that we have to, in the same way that people who are working to suppress the vote are using varied strategies in different venues, those of us who want to protect the rights, the right to vote and expand it, have to also be thinking in this sort of really nimble, multi-pronged fashion. So again, our state courts, certainly in New York, we are not in some of these other states where decisions might come down that are quite different. But in New York State, we have a court of appeals that respects process. And we have a constitution that is, at least as currently interpreted, going to be more protective of voters' rights when we're talking about gerrymandering than the U.S. Constitution. So we should focus on bringing more state constitutional claims. We should also be thinking about, all of these other access issues that I talked about at the outset. I don't know if any of you follow Democracy Docket. Sometimes it's a little bit of overload given the daily updates about voting related litigation, but we've got to think about that. Some of us who of how we are going to constantly challenge any efforts to make it harder, and we have to do it think about our state courts as a venue as well, instead of just being as federally focused as maybe we were for too long. But we also just need to educate our voters about what matters.
I have a question. Needless to say, as you were speaking about the voters being taken off the rolls in Georgia and so forth, and I found my shoulders getting more and more. So do you have anything hopeful about, like, the reason I'm asking that is, you're talking about swing states.
Mm-hmm.
And do you know of anything that's going on right now in swing states that is doing something to get people back on the rolls?
I do. And, we are here as the NAACP chapter in a nonpartisan fashion. But at this point, You know, I think it's fair to say that the DCCC and the Harris campaign have been proactive in ways that are intended to protect the right to vote and access in those jurisdictions in ways that we didn't see in the last presidential election cycle.
Hmm.
Okay.
Are you hopeful at all?
Very hopeful.
Okay.
I am
hope-
hopeful. I'm hopeful, but I'm always concerned about I don't want to say forget this election. I don't mean it that way. But let's just get past this election cycle. The damage gets done in our communities when people say, I came out to vote, and it did nothing. That is its own form of damage, regardless of what happens in this cycle. And part of the reason why that might be a legitimate feeling is because people are coming out to vote in a district that is drawn in a way that makes it impossible, virtually impossible, for their voice to be heard. And that's a hard thing to explain. You know, when I was putting together my notes for tonight, I forced my spouse to kind of listen to the discussion, and he was just like, come on, I'm getting tired. And you know, he's been conscripted into listening to all this stuff and cares very much about it. When we go out into our communities and you know, register voters or talk to them, and you've got to explain something like, you know, cracking and packing voters into districts. I mean, that's asking too much. And, you know, without going too far, I do think, especially with our younger voters, there's been a lack of civic education, period, but this is next level stuff. And social media makes it even harder to understand, because I do believe that when it comes to expressing preferences, we have a generation or a generation and a half at this point who are used to instantly expressing their preference, having it registered in a way that gives instant gratification. And yet, even with that being online, whether you like something or you repost something or there's this incredible architecture, this kind of IT infrastructure that makes that happen that you don't see. But they have the experience of saying, I like that post, boom, I have more fun. When you go out and tell that same young person to vote, they aren't seeing the incredible voting infrastructure, how the lines are drawn, whether the ballot is kept or thrown out. They don't see that. But then they also don't see the instant gratification of their candidate winning or their issue carrying the day. And that is really hard. And I do, even though I'm hopeful about this particular you know, election cycle's fight for voters, I do have serious concerns about, especially our younger voters, understanding what all is involved. You know, I started talking about you know, the NAACP president's comments at the DNC in large part because that history, I mean, it was before I was born, but not that far. And you feel it, you felt it in the room because you're surrounded by people who maybe were there at that 64 convention. Or they talked about, you know, I met older people. I met this gentleman he was the founder of an NAACP chapter in Massachusetts. And he was in I think he said he was 83 or so. And
Yes.
he was so great. We were chatting. And, you know, when you're sitting near or talking to somebody like that, you get a different feeling about what's underneath the right to vote than our younger people have. And so I don't have solutions for it, but once we're past this election cycle, I think, especially for the Civic Engagement Committee and for all of us who are involved in going out to register and work with voters, we have to start to sort of open the curtain a bit to everything that's happening behind the scenes that either is helping people to vote or making it harder.
Mhm. Okay. Is there any other questions?
I have a question, Barbara. It might not be on one of the topics, but do you remember in 2018 in Georgia when they sent someone to one part Randolph County, Cuthbert, Georgia, to close the polls? How
Mhm.
do you remember that? It was in 2018, and they showed the video about a week ago where I was at a missionary meeting in Christian education and lay council. And I had to speak on, they had asked me to speak on voter registration and get out to vote, how it affect the Black community. And they showed this video, and it was in the town that I was born and raised and went to school, Cuthbert, Georgia, Randolph County. And and I was in Georgia at the time, but I was in Atlanta, and I was on my way to Cuthbert because that's where my mother was at. And they had sent Kemp, the government, he wasn't the governor then, he was the secretary. And he had sent someone down there to close polls. But these Black people got together. They got together, and the NAACP came from different areas to stop them from closing the polls. And I got that video, and I want to show that video because it's a very powerful video. And a lot of people should see that. It's just like redistricting, and they was trying to close the polls so people couldn't go out to vote because the poll would be moved from where they would usually vote at.
And I can't say that I saw the video, but I mean, we've heard so many stories, especially out of Georgia.
Yes.
I mean, when Stacey Abrams was running, both times, really.
Right.
But there was Madeline mentioned the town hall that we had in Kingston about a month and a half or two ago. I can't remember exactly. And some of the comments were about these concerted efforts at misinformation and disinformation, because part of what you just talked about is, making it this kind of front end voter suppression where you're making it impossible for people to cast the ballot once they're trying to. Now the misinformation is making it so that people are sent to the wrong place.
Yes.
Or sent incorrect information. It's been going on for years. When I did voter protection up in Michigan in, I want to say 2004, people, it was on a Native American reservation. And so people who were known to be members of the tribe were getting these leaflets put under their front door, giving them wrong information about where and when to show up to the polls.
Yes.
Right. But that's that front end work. What's scary to me is all the back end, very technologically driven. With these, it used to be that if people wanted to suppress Black voters in the way that we just talked about, there would be a literal map on a table and a bunch of men, and they were, women weren't getting elected in those numbers. So they were a bunch of men around the table with markers drawing, okay, these are the lines and these are the people. Now there is such sophisticated modeling technology that can do predictive analyses of voter behavior. I mean, there's so much power, AI-driven power to target voters in precise and sophisticated ways. It's just taken this back-end voter suppression effort to a new level.
Yeah, I want to just jump in for a second that we often talk about Georgia and so forth. In the last presidential election before this one, a friend of mine who lives in a mixed income, mixed racial neighborhood in the Lower East Side, one of her neighbors got a call giving her, a Black neighbor, giving the wrong information of it, sounding very official. And she told me about it, and I called Letitia James' office, and within 5 minutes, an attorney called me back, got the number. I mean, so for what it's worth, I felt really proud of our, attorney general, because she took it seriously and went on it. So it's not only in Georgia. Here it is.
Not only in Georgia. I mean, it happened in Newburgh. We talked about that at the town hall. But what's wonderful about our attorney general is that she has always been committed to protecting voting rights and has staffed up a bit in advance of this election cycle.
Mm-hmm. Are there any other questions or comments for Barbara?
I got one more statement I want to ask Barbara. How do you, like in North Carolina, what they are going through now is about, they're trying to get Kennedy name off of the ballot. That's in North Carolina, right?
I think it's in a few states, but I don't want to
they-
speak out of turn as to which ones, but it's in multiple states.
Yeah, and they thinking that that would interrupt with the early voting.
Right, it's gonna delay the mail
Yeah.
out ballots.
Right, right.
You know, I did see, and that was on Democracy Docket earlier. I think there were ballots sent to the overseas and the service members that went out. Again, don't hold me to it because I don't have the email up, but I recall seeing that a portion of those ballots were going out and that others had to be reprinted. So I think that has likely been resolved, but you know, I wasn't involved with that litigation, so I can't speak with great authority.
Okay.
I have just a really brief comment. When Christine asked about hope, and it's just such a simple little formulation that's I have found really useful in over the years, talking with people who maybe are just feeling demoralized or like questioning whether what we do makes a difference. And it's really so simple. Imagine what things would be like if we weren't doing any of these things. I mean, just imagine for a moment what things would be like if all of these different efforts that Barbara has talked about and things that we know of and that we've been involved in. Imagine if none of those things were being done. I mean, it's just a simple little formulation, and it's absolutely true. I mean, it's the difference is just gargantuan.
I also just want to say, because you know, in preparing my notes, I definitely focused on things that might drain our hope. But you know, one thing that what makes me feel hopeful is even in Ohio. I don't know if you saw, you know, there was that sheriff who was accused of, you know, telling people to write down the names of their neighbors that had up, you know, Democratic candidate signs.
Yes.
And there were local Republicans who spoke out against that.
Mm.
And to me, that gives me some hope, because at the end of the day, you know, there are decent people everywhere who don't want that type of behavior going on in their communities.
Yes. Yes.
Anyone else? Barbara, thank you. You,
Well-
as always, Maud has
No,
something.
after you thank Barbara, we have some announcement we need to draw our
Okay,
attention.
but I'm wanting to thank Barbara. As always, you are inspirational and always very knowledgeable. And I thank you for presenting with us tonight.
Thank you so
Barbara.
much. I'm going to step out, but I look forward to working with you all more on some of these voter registration efforts.
Okay.
Thank
Okay.
you.
Bye-bye.
Bye-bye, Barbara.
If you see your announcement, we already announced about the state convention, and the civic engagement committee is the leading committee and getting out the setting up the programs for getting out the vote. And we had our voter registration is set up every Wednesday at the market to market. And we had a voter registration set up today in the school. Celebrate National Voter Registration Day was today. So we did very good on that voter registration and registering the youth. Our open house in the Ellenville Central School will be held on Thursday, September the 9th at 5 p.m. And the NAACP has been invited back to set up a voter registration table for the parents that attend and may not be a registered voter. The NAACP Meet the Candidate Night will be held Tuesday, October the 15th, 2024, in person at the Ellenville Public Library Community Room at 6:45 p.m. And the reason I'm saying 6:45 p.m. because that Tuesday is the Tuesday that the nomination committee have to give their report. October the 15th at our next membership meeting. The nomination committee will be giving their report on October the 15th. And then a supervisor committee for the branch election will be elected that night on October the 15th. Those are the branches announcement. Anybody got any questions about the announcement? If not, unmute everybody. Can everybody unmute? Okay. So it's 7:44 p.m. and I move that the meeting be adjourned at 7:44 p.m.
I second it.
Okay, been proper moved to second that the meeting be adjourned at 7:44 p.m. All in favor, let us hear say by aye.
Aye.
Motion carried. Good night, everybody.
Good night,
night.
everyone.
Thank you.